Welcome to the Silica Exposure Training for the cut stone industry. This training covers the identification, evaluation, and control of silica exposures in the cut stone and stone fabrication industries. The training was developed by Georgia Tech's Safety, Health, and Environmental Services Group with funding from the U.S. Department of Labor's Susan Harwood Training Grant Program. This is Lesson 9, Know Your Rights. Before we look at your rights today on the job, let's take a look back to how things were when it comes to silica exposure in the past.
1935, a wave of fear was sweeping the country. Silicosis was taking its toll from the ranks of American workers. Cause of the disease, dust. Results of the disease, disablement, poverty, death. Cure for the disease, none. Throughout America, workers exposed to dust grew fearful of their health, of their very lives. 1936, amid these alarming events, the Secretary of Labor called together a national conference to study this disease. A committee of 60 experts was appointed, and a year later reported to the Secretary of Labor. But let's hear from Miss Perkins herself.
After a year of work, the National Silicosis Conference Committee has just made its report of findings and recommendations, and I feel it to be my duty to make this report available to the working people of the United States and to their employers by every available method. This report shows how silicosis occurs, where it occurs, and what the disease is, and it makes recommendations for its practical control. Above all, the report emphasizes that these control measures, if conscientiously adopted and applied, that silicosis can be prevented.
It was not until 1970, with an act of Congress, that the Occupational Safety and Health Administration was created, known as the OSHA Act. It assured safe and healthful working conditions for men and women by setting and enforcing standards, as well as providing training, outreach, education, and compliance assistance. When OSHA was created, an estimated 14,000 workers were killed on the job each year. We're about 38 people every day. Over the past 50-plus years of protecting workers, OSHA has made great strides in workplace safety and health. However, significant hazards and unsafe conditions still exist in U.S. workplaces. Each year, more than 3.3 million working men and women suffer a serious job-related injury or illness. Millions more are exposed to toxic chemicals that may cause illnesses years from now, including silica. OSHA covers private sector employers and workers in all 50 states, the District of Columbia, and other U.S. jurisdictions, either directly through federal OSHA or through an OSHA-approved state plan. State plans are OSHA-approved job safety and health programs operated by individual states instead of federal OSHA. An example would be Cal OSHA in California or North Carolina OSHA. OSHA approves and monitors all state plans and provides as much as 50% of the funding for each program. State-run safety and health programs must be at least as effective as the federal OSHA program. The states in blue have approved state plans, and the states in gray cover state employees as well. Employers must also perform tests in the workplace such as air sampling or noise monitoring as required by some OSHA standards. Provide hearing exams or other medical tests required by OSHA standards if applicable. Post injury and illness information so that employees can review them. And promptly display the OSHA Job Safety and Health It's the Law poster that describes rights and responsibilities covered by the OSHA Act. And employers may not retaliate or discriminate against workers for using their rights under the OSHA Act to report hazards that could lead to or have caused a work-related injury or illness. Employers have the responsibility to provide a safe workplace free from serious hazards and must follow all OSHA safety and health standards. OSHA requires that employers first try to eliminate or reduce hazards by making feasible changes in working conditions rather than relying on personal protective equipment, also known as PPE, such as masks, gloves, earplugs. And if an employer provides PPE, then the employer must train the employees on when and how to use that PPE. Any training given by the employer must be in a language that the employees can understand. Temporary workers are also entitled to the same protection against retaliation as full-time workers. Employers may not take action against employees for participating in protected workplace activities, such as filing a complaint or voicing concerns about workplace hazards to supervisors. If employees feel that their concerns are not being addressed by the employer, they are protected by the Whistleblower Protection Act to file a complaint with OSHA without fear of retaliation or losing their job. If OSHA shows up on site, workers can participate during an OSHA inspection. They may speak with an inspector in private without retaliation from an employer. Workers can see the OSHA citations and any other documentation. Even if you are a temporary worker, you are entitled to the same protections as any other worker. What this means is that your host employer cannot ask a staffing agency to remove a worker for reporting safety and health hazards. If the staffing agency complied and removed the worker, both the employers may be investigated to determine if one or both retaliated against the employee. Retaliation includes blacklisting, demoting, denying overtime or promotion, disciplining, denying benefits, failing to hire or rehire, firing or laying off, intimidation, making threats, reassignment to a less desirable position, including one adversely affecting prospects for promotion, and/or reducing pay. Employers are required to maintain records of any injuries or illnesses that occur as a result of work-related activities. Adequate records of injuries and illnesses must be maintained and kept on file for at least 5 years. Employers that have more than 10 employees must keep the OSHA logs. All employers must comply with OSHA standards and report OSHA accidents that involve fatalities, amputations, loss of an eye, or hospitalization of one or more employees. Fatalities must be reported within 8 hours, and amputations, loss of an eye, or hospitalizations must be reported within 24 hours. The OSHA 300 log contains descriptions of recordable injuries and illnesses that occur on the job. The OSHA record-keeping forms must be maintained for 5 years at the establishment. Your employer is required to update logs to reflect any changes that occur and post the summary log from February 1st to April 30th of the following year. OSHA's website has a lot of information on employee and employer rights and responsibilities. The website also has a lot of information and documents that can be helpful for employee training, including e-tools, presentations, fact sheets, and quick cards. We work with the Georgia Tech Safety and Health Consultation Program. We provide free on-site safety and health consultations for small businesses in the state of Georgia. The consultation program exists in every state. It is a no-charge service and completely confidential. Most cut-stone countertop fabrication companies qualify to participate in the OSHA consultation program. Consultants are able to conduct noise monitoring and assess employee exposure to respirable crystalline silica. Ask your employer to request the service through the links provided in the video description. Thank you for watching Lesson 9 of the Silica Exposure Training for the Cut-Stone Industry, a training on the identification, evaluation, and control of silica exposure in the cut-stone and stone fabrication industries. This material was produced under grant number SH37200 SH1 from the Occupational Safety and Health Administration, U.S. Department of Labor. It does not necessarily reflect the views or policies of the U.S. Department of Labor, nor does the mention of trade names, commercial products, or organizations imply endorsement by the U.S. government.